Ma'am, if you would please raise your right hand and take an oath. Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please speak towards the microphone, and if you would state and spell your name for the record.
Yes, my full name is Katherine Lonstein, Katherine Lonstein, but everybody calls me Katie.
All right. Ms. Lonstein, what professional field are you involved in?
I'm an attorney.
Okay. And where did you attend law school?
Here at the University of Georgia.
And what years did you attend school at the University of Georgia?
2000 to 2003. Before
you got to UGA, where did you complete your undergraduate degree?
At the University of Virginia in Charlottesville.
All right. And in law school, can you describe the way during the first year of law school that the student body is divided?
Yes. So we're divided into 3 sections, X, Y, and Z. And you have all of your classes with the folks that are in your section for your entire first year.
And while you were in law school, did you ever meet an individual named Tara Louise Baker?
Yes, I did.
Okay. And when did you meet Tara?
Very first day of law school. We were in orientation, and that was the moment.
And so when you say that was the moment, it seems like it was a quick friendship. Can you talk to us about that?
Yes. Literally from that moment, Tara and I and another woman named Jenya became very good friends. I don't remember many moments of law school after that we weren't together, studying, walking, anything.
All right. So can you explain to the jury kind of the academic rigor involved in that first year of law school?
Yes, exhausting. You are in class 5 to 8 hours a day, then you are studying another 5 to 6 hours a day. If you're lucky, you sleep some, eat some, but it is one of the hardest things I've ever done in my entire life.
That experience, and in particular, sharing it with the same people in every class, did you find that to increase or impact the way relationships were forged at all?
Yes. You form these bonds through the stress that you're going through. You're all learning the same thing, you're all studying the same things, and you're all exhausted in the same way. People would form friendships that would turn into marriages. People would form friendships that turned into lifelong friendships. It's just unlike anything I've been through before. It's like being in the trenches, I suppose, although, I don't know other way to describe it.
All right. And so would you say that you would you characterize your relationship with Ms. Baker as falling into that category of relationships?
Yes, I would say from early on, I have called her one of my best friends. And I know it feels too short, but I don't know how to describe it other than if you don't go through that sort of very difficult thing with someone and it bonds you in this really particular way.
And as it relates, I think you've already testified to this, but there are 3 sections. You take all your classes with that section that you're in. Is that right?
Yes, first and second semester, your whole first year.
Okay. I'm going to show, Your Honor, Mr. Cruz, what's marked as State's Exhibit 34. And, Your Honor, I ask for permission to approach the witness and then continue to move freely through the well of the court as I question her. Right. Ms. Lonstein, I'm going to hand you State's Exhibit 34. I'm going to ask you to take a look at that. Once you've had a chance to review it, let me know.
Yes, I have seen it.
Okay.
I've looked at it.
Do you recognize it?
Yes, this is the schedule from our second semester, so beginning of January 2001 here at law school. Mm-hmm.
Does that appear to be a fair and accurate depiction of what your schedule was for that semester of law school beginning in January of 2001?
It does.
Judge, I move to tender states 34 at this time.
Any objection, Mr. Cruz? It is admitted.
And, Your Honor, I'm not going to necessarily ask to publish this to the jury at this point, but I'm going to hand it back to Ms. Lonstein. As it relates to Fridays for y'all, did y'all have classes on Fridays?
Yes.
All right. And what classes did you have?
We had property property, tort, and civil procedure.
Okay. And property, was that the first class of the day?
Yes.
All right. And what time did that property class start?
9:30 in the morning.
And I don't think we covered this, but are you still practicing law?
Yes, I am.
All right. Where do you practice law?
I live in Washington, D.C., and I work for an agency called the U.S. International Development Finance Corporation.
And so backing up now, back to January of 2001, I want to ask you about a Thursday evening, which would have been January 18th of 2001. Would you and Miss Baker ever study together?
Frequently, if not every day.
Okay. And so where would y'all study when you studied?
So the law library always, but there are different parts of the law library. There's this sort of first room you come into that has these big windows and it's very sun-filled, but it's a more casual part where people sometimes have conversations. So sometimes you would study there if you were doing a study group or if you were just reading and it wasn't too intense. And then there's this walkway you can go through and you go into the quiet part of the library. And that's where you would go if you were studying for an exam, trying to write a paper, trying to focus.
Okay. And so that evening on that Thursday, were you and Miss Baker studying together?
Yes, we were in the quiet part of the library.
Okay. And as best you recall, I recognize as we sit here, it's been over 25 years since that night. Do you recall about when Miss Baker may have arrived at the law library to study with you?
Yes, I think she got there around 7:30.
Okay. And do you recall what y'all may have been working on?
I believe it was a paper. It was definitely more than just like marking our law books because we both had our computers. So I believe we were writing something. And I know it sounds early because it was early in the semester, but that's just law school for you.
And as it relates to kind of that semester and Miss Baker's plans, was she approaching that semester with any kind of renewed or, I guess, elevated level of commitment to her grades?
Yes, absolutely. In fact, we all were, but she was the most organized, so she had a definite plan, whereas people like me were like, I'll try harder. But the end of our first semester was probably a bit of a shock to all of us, or, grades are hard. So her plan was to be more rigorous about her time in the library and to sort of make it into a job, like ending time, definite stay for the whole period.
And is there any particular ending time that you recall that Miss Baker was committed to?
Yes, it was 10 p.m.
Okay. So that evening, did you stay till 10 p.m.?
I did not. I had been at the library before. She had joined me there. So at that point, I was ready earlier than she was to go home. So I probably left around, I want to say around 9. Could have been a little bit later, but probably around 9.
Okay. And so was Miss Baker the type of person who had a lot of concern for the people around her?
Yes. I had to walk to school from based on where I lived. I lived just over the railroad tracks, above where the Blind Pig Tavern used to be. And so, not the safest of routes. So anytime I had left the library or school or anywhere before her, she would insist that I call her when I got home.
And so the area that you're describing, please correct me if I'm incorrect, but if you come down East Campus Road going from North Campus to South Campus, and you turn left onto Research Drive, I believe it is. It goes by that area that you're talking about.
I think that's right.
Yeah, sorry.
No, sorry.
Go ahead, but I think I misnamed that street, but if you turn left underneath where the railroad tracks go over. Is that what you're talking about?
It's in that direction, yes. It's actually been torn down and is a parking lot now, but that's the right direction, yes.
Okay. And so did she had that concern, did she ask you to do anything? Well, and that's going to call for hearsay. So I'm going to withdraw that question, Your Honor. Were you supposed to do anything when you got home?
Yes, I was supposed to call her when I got home, and I did not.
All right. And so did you receive a phone call that evening?
Yes, she called me about 9:30, maybe 9:45, and then she admonished me, scolded me because I had failed to call her, but I just didn't mean anything by it. I just forgot.
Okay. Do you need a cup of water or a moment?
I have some. Thank you so much.
There's some tissues over there beside you if you see them and need them. Is that the last time you ever talked to Tara?
Yeah. I think the last thing she ever said to me was I said, hello, and she said, you did not call me. And I said, I know, I'm so sorry. And she said, but you're okay? I said, I am. And she said, all right, I'll talk to you tomorrow. And that was kind of it.
So when you say I'll talk to you tomorrow, this is Thursday night.
Yes.
So tomorrow would be Friday, January 19th, 2001. Is that right?
Yes.
I would just object to leading questions. I've given counsel leeway. I didn't want to just make.
All right.
I would ask the court to instruct them to ask appropriate questions.
All right, I'm going to sustain that objection if you will rephrase your questions to be non-leading.
Yes, Your Honor. What day would the next day have been?
January 19th, 2001.
And what day of the week would that have been?
Friday.
Okay. And so on Friday, what would y'all's first class of the day have been?
I believe it was property.
All right. And I think we already talked about this, but about what time did that start?
At 9:30 in the morning.
Was Tara in class?
No, she was not.
Was that something that was unusual for Tara?
It was. And we did, I recall my friends and I discussing it, but we thought, well, it's her birthday weekend. Maybe she slept in,
Okay. Did she show up for any of her classes after that?
No.
I'll make the same objection. We've had 3 leading questions. That the state asks questions appropriately.
All right, so the prior 2 questions were leading. I'm going to sustain your objection with regard to that and ask the state to make sure that you rephrase and you don't lead your witness. The last question was actually not a leading question, so I'll overrule your objection with regard to the last question. You may continue.
Thank you, Your Honor. So I think the last question I asked you is, did Tara show up for any of your classes that day?
She did not show up for any of our classes. No.
Okay. Were there any plans that y'all had for that evening?
Yes. As I said, it was her birthday weekend. So we had all planned to meet at a bar called The Winery just after class. And we did go. Her friends and I went, and she was not there.
Okay. When did you find out what had happened to Tara?
The next morning on January 20th.
Okay. How is it that you learned about Tara's murder?
A friend of mine from law school named Jim Davis called me, and he said, Katie, I'm so sorry, but Tara's died. And I yelled at him, and I was very mean. I told him he was not funny, and then I hung up on him. And then I called our friends. We called them the Ericks because they lived in the same house. So I called the Ericks, and one of them answered. And I said, Eric, Jim has said the most insane thing to me. And he said that Tara died. So I need you to go get your paper and tell me he's wrong. And he did. He went out, and when he came back onto the line, he was just very and he said, Katie, I'm sorry. She died. I don't remember her.
Any response, Mr. Yellowman-Shilley, with regard to the hearsay objection?
Ms. Lonstein, I think the court's instruction to you would be, and my instruction is that please don't talk about in your answer anything anyone else said to you.
Fair enough.
Any objection? Continue.
I apologize. After that, I asked the friend that I was with to get me a newspaper. So that person did purchase me a newspaper. And then I saw the headline, Student Slain, and then the next thing I remember is I fell down, and then I started crying, and I don't know when I stopped, but that's how I found out.
I want to ask you a little more about your relationship with Tara. And I think, Jenya also seems to have been part of this group. Is that right?
Yes.
Okay. Would Tara share things with y'all that she didn't share with kind of the rest of the law school section and class?
That is my perception, yes.
Okay. Was there anything related to her last name that she shared with you that she didn't share with the rest of the law school section and class, to your knowledge?
Yes. To my knowledge, this was something she kept a little more private. Her name had been Barker. It was the name of the man who was her biological father, and she had changed it pretty close to law school, from my understanding, to Baker, which is the man she calls her daddy, his last name.
Okay. Were you aware of whether or not Tara was dating anyone?
Yes.
Okay. And who is that person, if you know?
His name was Chris. I'm sorry, I don't remember his last name, but yes, she was dating Chris, and she'd been dating him for a while, as far as I knew.
Did Tara, and I'm not asking you to get into anything Tara said to you, okay, but did she ever talk to you about Chris?
Yes, in a very normal way. We talked about our friends, we talked about our families, we talked about our relationships. I myself was in a relationship with at a time, so we shared stories like that.
What was, based on those conversations with Tara, what was your impression of their relationship?
That it was good. She was positive. She would smile when she talked about him. No, nothing except for happy.
I don't have any other questions. Thank you very much, Ms. Lonstein.
Cross-examination, Mr. Cruz.
Sorry for your loss, Ms. Lonstein. Your Honor, I do not have any questions, but I would ask if we could approach.
All right, may approach. All right, ladies and gentlemen, I'm going to excuse you for right now. If you'll go into the jury room, don't talk about the case. We'll be with you shortly. There are some things I need to take up outside your presence. Thank you. All right, Mr. Cruz, do you want to clarify your question and see if I understand what you're asking?
Yes, ma'am.
Go ahead.
Before our trial, I filed residual hearsay motions. The Honorable Court entered an order stating that I could not ask any witness anything about what Ms. Baker told them until, I believe you prefaced it on, depending on what Chris Melton's testimony was. You said you would make a ruling after, I'm going to paraphrase, you would make a ruling once Chris Melton testified. You instructed me that in opening, I could not mention anything that Ms. Baker may have said to anyone. And as you know, in opening yesterday, I was held in contempt for making a statement that Chris Melton made that the Honorable Courts, that Mr. Yalman-Chile asked for, and the Honorable Court granted, saying that I violated Rule 412, based on me stating that Mr. Melton stated she must have been with someone else when he was told that somebody else's DNA was found after he knew for 25 years somebody else's DNA was, or at least he was told DNA was present. Based on yesterday, I said, well, look, I need to be conservative. I don't want to offend the court in any way. I don't want the court to think I'm doing anything intentional when I'm not. So I assumed that Ahmad, don't speak on anything regarding Tara Baker's statements until the Honorable Court makes a ruling. However, Mr. Yanamachili just asked Ms. Lonstein, based on what Tara Baker told you, what is your impression of the relationship? And I looked at the Honorable Court to see if the Honorable Court was going to say anything. Nothing was said. So that's why I came to the bench, to just get clarity. And the only thing I want to do, Your Honor, I just don't want to offend you. I don't want to offend you. Yesterday, I got held in contempt, and I didn't even realize that I was doing something that was improper. So I'm trying to make sure I'm walking on eggshells for Your Honor. I'm trying to make sure I do everything right for Your Honor. So I just want clarity that if that question is okay based on the court's order. That's the only thing I want clarity on. Can I ask witnesses, based on what Ms. Baker told them, what is their impression of the relationship with Chris Melton and Ms. Baker?
All right, Mr. Cruz, you are mischaracterizing the court's order completely. Yesterday's moments were based on a ruling that the court made on January 21st with regard to the state's appropriate filing of a 412 motion. And we've said this, we've discussed this over and over again. And the court has noted over and over again that the defense did not file a 412 motion. The defense only acknowledged in open court to the state, with regard to their motion, that the only person that they would introduce or attempt to introduce evidence for with regard to any exception for 412 was Mr. Melton. And we've discussed over and over again the fact that should the defense wish to attempt to introduce evidence other than Mr. Melton, that a proper motion had to be filed. We've talked about that over and over again. Yesterday, I made a finding that you first attempted to circumnavigate that policy, that procedure, by insinuating certain things in your opening. The state made an objection. I sustained it. And I had a pretty lengthy discussion with counsel outside the presence of the jury, warning counsel not to do that. When you did it again, the state made an objection. I sent the jury out, and that's when I made a finding of contempt after allowing you certainly to explain yourself. And I found that that was a violation of the court's order with regard to 412. And so your characterization for the court about what you're allowed to say and what you're not allowed to say is not, does not comport with what happened yesterday. The motion that you filed, notice of intention to introduce residual hearsay testimony, is in relation to certain statements that you are asking the court to admit. They are pending. And they are pending because I made, and you appropriately said this, it will depend on how the evidence unfolds. And we will take up these motions again, if necessary, as the case proceeds. But there is nothing improper in the way that Mr. Yellowman-Chili asked that question. And it has nothing to do with 412. It doesn't have anything to do with my prohibition that I gave the defense. I think the insinuation that the court is being unfair and allowing one side to do something and the other side not to do something is absolutely mischaracterizing my order. And so I'm responding to your comments, Mr. Cruz. If you have an objection to the state's questions, you certainly may present it right now, and I will make a ruling.
This is the situation the defense is in. I am handcuffed. Being held in contempt is a very severe sanction against an attorney. It is very severe. So what I have to navigate is being respectful to the court, also following the law, but but most importantly, following the court's orders. The state, they have no prohibitions on him. I can't argue consent. The court said, well, you can't say anything about consent in regards to the DNA. Mr. Yalamachili, who got up yesterday and said, oh, Mr. Cruz is so disingenuous. This prosecution is disingenuous. This guy is innocent. The evidence will show he's clearly innocent. So, but I won't go there. But we have restrictions on us that the state does not have. So what I have to do, because I've been held in contempt, is I have to make sure I don't do anything that'll surprise me like it did yesterday.
Okay.
So
Mr. Cruz, I would like to respond this way. Your characterization of being handcuffed, so you speak, is very unfortunate. And I think that is an unfortunate way to address the fact that the only reason that we're having this discussion is because you have not filed the appropriate motions for the court to take up. And the ruling that the court made about whether the defense can introduce a defense of consent and other things that you mentioned are because, and we have talked about this many times, that you have failed to file the proper motions. Because when you file the proper motions, the court will hear argument as to whether your motions are appropriate, as to whether the evidence you are seeking to admit is admissible. And if that is not done, then what you're seeking to admit is not allowed. And that is just the law. And so to characterize the court's allowing one party to do things and the other side being, in your words, handcuffed is not accurate. It is misleading. That is not why the court made a finding of contempt yesterday. I'm not going to go back over my finding, but suffice it to say, I think I was pretty thorough on the record twice about whether the defense was allowed to say certain things. The rulings that I have made that supported the court's comments yesterday are in the record. They are on the record. And Mr. Cruz, you are very well aware of the reasons that the court made those rulings. And so unless and until the defense files the proper motion, which would then provide the atmosphere for both sides to argue as to whether the evidence you're asking to admit is admissible, it is prohibited. And that is the law. And so I'm not going to argue with you about that. I think your characterization of what is allowed and is not allowed is mischaracterized. I can't think of another way to say it.
Your Honor, we gave 5 cases that 412 did not apply to a defendant saying that to a rape allegation, he's raising the defense.
I'm not going to revisit that moment, Mr. Cruz. I've already made my ruling.
Yes, ma'am.
And so it is not appropriate to re-argue that you're right and the court is wrong. There is another venue for that.
Yes, ma'am.
I've made a ruling, and you certainly can take it up if necessary in another venue. But for now, I'm not going to revisit that ruling.
Yes, ma'am.
I've made that ruling. And unless until you are filing the appropriate motions to be heard, and I've told you yesterday that if you do file those motions, even though they are not timely, I will consider them. But until then, my ruling does stand. And so I just need to ask you your objection right now so that I know that I've finally finished making whatever ruling it is with regard to what Mr. Yalamachili was talking about.
So I didn't have an objection. That's why I approached the bench. The question that I was asking, because maybe I'm misinterpreting what the Honorable Court instructed me to do and to stay away from. I just want to know, because what I'm scared of is I ask the question, Mr. Yalamachili hops up, Judge, he's done this on purpose, hold him in contempt again. I'm just asking, Judge, is it okay? And we could have kept it at the bench. Is it okay? I just want to be clear. Is it okay if I ask witnesses the exact question? Based on what Ms. Baker told you and what she discussed in her relationship, what was your impression about Ms. Baker's and Chris Melton's relationship? Is that an okay question for me to ask?
Yes, it is, sir.
Yes,
That's what the state just asked.
Yes, ma'am.
Yes, sir.
Thank you, Your Honor.
And that was one of the moments with regard to that particular witness, Mr. Melton, that was basically properly noticed by the defense to the state, because we had a hearing where we had that discussion. And so even though that notice was an oral notice as opposed to a written motion, We had that discussion in court. My ruling on the 21st was based on that acknowledgement by the defense to the state in proper form. So yes, sir. The answer to your question is yes. Mr. Yalmanchili, did you want to respond at all? I've been talking with Mr. Cruz. You're the other party. If you'd like to make a response, you may. And then, Mr. Cruz, you'll have the last word. Go ahead.
Thank you, Your Honor. As the court said, the issue Mr. Cruz actually raised at the bench where the discussion started had nothing to do with 412. The court's already said we're not revisiting the long discussions. The court's reviewed all the cases, made its ruling in accordance with the laws of the state of Georgia. I just want to, I guess, establish for purposes of the record that Mr. Cruz filed a notice of intent to introduce residual hearsay statements. So asking to actually elicit hearsay from witnesses. The court withheld its ruling. I do want to say that at least, and I don't have the transcript in front of me, but I think Mr. Cruz has misconstrued the court's order as it related to that, which was we are going to hold rulings on this notice until such time as there has been testimony from the witness and some of the predicate requirements may be met about truthfulness, and then the court, obviously it will be in your discretion even to admit or deny the introduction of those statements. But I just want to establish for the record, the state did not elicit any hearsay statement regarding Ms. Baker saying what it was about the relationship. We established foundation that this is a person who had discussions with Ms. Baker about her relationship, and we laid a foundation that they had a close and trusted friendship, and then just asked her about her impressions of their relationship. So I just want to make that clear for the record.
And I think that's an important distinction. So, Mr. Cruz, with regard to your question, let's go back to your question. Your question about eliciting information about the witness's impression of any status of relationship between Ms. Baker and Mr. Melton is certainly permissible. The state just asked it. The defense can ask the same thing. What neither party can do right now is elicit hearsay testimony. And let me just rephrase so we're on the same page. Because sometimes these things can get very technical, and I want to make sure that all parties are on the same page, and that is this. For example, asking a question of this witness or any witness, based on what Ms. Baker told you, do you have an opinion on X, Y, and Z? At the moment, that's not a permissible question, right? Because it is eliciting hearsay. The way that Mr. Yalmanchili has just phrased what he asked this witness is permissible based on your relation. I'm not going to tell you how to make your question, but something to the effect of how he just phrased it, based on your relationship with a certain person, the hours you spent together, the things that you discussed, do you have an impression of the relationship? That kind of a question is permissible. The state just asked something like that. The defense has every right to respond and ask the same kind of a question. But eliciting actual hearsay testimony is not permissible at this point. Does that make sense?
I agree with the Honorable Court's ruling. I just wanted to make sure that I'm within the proper parameters. And just to let the Honorable Court know, exactly where we're coming from as the defense. It is new ground when a prosecutor stands up and says, Judge, this attorney has said something and he should be held in contempt, and he's held in contempt. When the statement, again, that Chris Melton said she must have been with someone else when confronted with DNA has nothing to do with 412. I am very familiar with the 412 statute. That has nothing to do with 412.
We're not.
Go ahead, Your Honor.
I'm sorry, Judge. Just because Mr. Cruz has directly referenced statements that I've made, I would just like to say I've never in my career as a prosecutor or a defense attorney, thankfully, until this trial, been put in a situation where I had to make that request, but we were put in a situation where we had to make that request.
For both parties, I'm not going to relitigate the moment where I've held you in contempt, Mr. Cruz.
Yes, ma'am.
I am going to tell you that the comments that you have made, in my opinion, are mischaracterizing what happened yesterday. I'm not relitigating that moment.
Yes, ma'am.
I'm going to ask that all parties move on.
Yes, ma'am.
It is 5 after 12. I'm instructing both parties not to violate my ruling on 412. If there is a motion filed, even though it is untimely, I will consider it. But other than that, we need to move along. So is there anything else, Mr. Cruz, you would like to ask the court?
No, ma'am.
All right, thank you.
Your Honor.
Yes.
Just to let you know, I am walking on eggshells. So if I have concerns about something, I'll just ask to approach the bench. It doesn't even have to be on the record. I just want to make sure I don't violate anything that the Honorable Court puts in place.
Well, Mr. Cruz, I'm sorry to hear that.
Yes, ma'am.
I don't know that walking on eggshells is a fair representation of what happened yesterday. I think the appropriate response should be to review the court's rulings and just recognize what they are and not violate them.
Yes, ma'am.
All right, thank you. If you'll bring the jury up, please. Thank you.
Send it for the jury.
Thank you. Everyone may be seated. Mr. Yalamichili, you have the floor.
Thank you, Your Honor. I believe Mr. Cruz indicated that he didn't have any cross-examination questions for Ms. Lonstein, and I don't have any.
I'm not sure I heard that. Okay, so you were finished. Mr. Cruz, do you have any questions for this witness?
I do not, Your Honor.
All right. Mr. Yalamichili, anything else from this witness?
No, Judge.
May she be excused?
We'd ask that she is.
Any objection from the defense?
No, ma'am.
All right. You may be excused. Thank you. May I see counsel